And now let's talk about what truly matters to our legal experts here. Avery Friedman, civil rights attorney and law professor in Cleveland. Richard Herman, a New York criminal defense attorney and law professor. Joining us from Vegas. We got Cleveland, we got Vegas. This is great. Thanks for joining us, fellows. Appreciate it. Let's start with what we heard there in that last excerpt from the prosecutor. If you had any doubt, wasn't it erased by what George Zimmerman said afterwards? All the lies. Let me ask you something. Richard Herman, let's start with you. Is that enough to convict somebody? That you say someone's a liar?
No, that's not enough. They have a burden of proof. The prosecution has a burden to prove beyond and to the exclusion of any reasonable doubt that George Zimmerman did not have the right to self-defense. And I must tell you both, Kate and Chris, they have utterly, completely failed in this obligation. I am shocked that it's taken the jury this long. I am shocked the judge did not dismiss murder two as a matter of law, or at least reserve on it. The summations by the government were just emotional pleas to this jury, as opposed to Amara's, which surgically showed them the law and the evidence and left them with no alternative. It must be not guilty.
When manslaughter was added into this kind of towards the end, some people were kind of thinking, well, that indicates that it seems like that might be a better route, a better avenue for the prosecution to go to kind of target. It's an easier burden, it's an easier threshold to meet. But as you're listening to closing arguments by the prosecution, it sure sounded like they were still targeting and aiming for second-degree murder. What do you think?
Yeah, for the top charge. That's what they're looking for here. But manslaughter, we knew this was coming. It's as of law in Florida. Yep. They have to charge this. So if the prosecution wants it, they charge it. There's no defense to that. Don't think for a moment, though, if this case gets appealed to the 11th Circuit, I mean, if you want to look at the success rate on defense appeals in the 11th Circuit, you need a microscope because it's minute. If Zimmerman gets convicted of manslaughter, which is a second-degree felony, he's, again, aggravated by the use of a gun and the fact that Trayvon Martin was a minor at 17. I mean, he could be looking at 30 years in prison on a manslaughter conviction. It's not there, really, and nobody knows what's going on right now, and I'm just speculating, but I think in my mind... All right, but the fact that they're working through lunch, I think they're close. I think they probably have 4 on the side of acquittal, maybe 2 outstanding who wanted to look at all the evidence yesterday. And you could see a hung jury on manslaughter, but an acquittal on the murder too.
It's one of the highlight moments that really stuck with people, and you can imagine also stuck with the jury. Do we have that do we have that clip? Let's go to that.
That's cement. That is a sidewalk. And that is not an unarmed teenager with nothing but Skittles trying to get home. That was somebody who used the availability of dangerous items from his fist to the concrete to cause great bodily injury. Not that it's necessary for self-defense, but great bodily injury against George Zimmerman. And the suggestion by the state that that's not a weapon, that can't hurt somebody, that can't cause great bodily injury is disgusting.
Is disgusting, Mark O'Mara says. So, Richard, what do you think? What do you think that impact had on the jury?
I think it's disgusting, and I think it had a tremendous impact of the jury. You know, Kate, they're trying to show that he was a young boy walking armed with only Skittles. I'd like to know how many young men age 17 the state tries as adults, but in any event, that was pretty demonstrative. I mean, look at the evidence, the credible evidence that came in. He was punched in the face. His nose may have been broken, may not have. Blood was certainly going down his throat. His head was being banged into the ground there, partially on the cement, at least 2, maybe 3 times, maybe more. John Good, the neighbor, saw the movement, saw the punches to the head. He had no dog in this fight. It was dark. It was raining. Did George Zimmerman, in his mind, reasonably fear imminent death or severe injury? Was it reasonable for him to believe that? The answer has to be yes. It can't be.
Hold on a second.
You can't wash off the blood and say, "Oh, look what actually happened to him." You can't do that.
All right, hold on a second. I'll say yes, you can. Here's why. You guys are too much on the same side. And there's another side of this case. So let me present why.
It's rare.
It could be. I know it is. It's too rare right now. I have to defeat it. So let's just offer up what's the other side that could be going on in this room. Do we know that this piece of cement was used as a weapon? Do you believe the jury has been presented with evidence that beyond a reasonable doubt shows that Zimmerman's head was bashed against concrete when there was a lot of discussion about them winding up on grass? Do they know beyond a reasonable doubt that those injuries were caused by that? Or is there just as good a chance that they're back there thinking, sure, he got hurt. This kid had some advantage in the fight, but it wasn't serious bodily injury. It was fist fight injury. It wasn't something that would have triggered his ability to reasonably use a weapon against a kid who was unarmed. So now what do you think of that?
Chris, you have too much prosecution in your blood there. I mean, and please give my best to your brother and especially your dad. But
don't try to curry favor with me, Herman.
It doesn't work.
I got to do that first. I got to come with that first.
All right, Richard, wrap it up. Give me your final thought.
Listen, the unrebutted evidence is that the head at least hit the concrete 2 or 3 times. That's unrebutted. And Chris, in the prior segment, you said there's so many what-ifs and so many things that are not connected here. That's reasonable doubt. That's why there must be an acquittal in this case. It can't go any other way. There must be an acquittal.
In the Circuit Court of the 18th Judicial Circuit in and for Seminole County, Florida, State of Florida versus George Zimmerman. Verdict: we, the jury, find George Zimmerman not guilty. So say we all foreperson.
Does either side want to poll the jury?
We would, Your Honor.
Okay, ladies and gentlemen, ladies, I'm sorry. As your juror number is being called, please answer whether this is your verdict.
Juror